Welcome back to Newsday. A chieftain of the All Progressives Congress, Daniel Onjeh, has defended the decision of the Benue State Governor, Hyacinth Alia, to remove Justice Maurice Ekpambese as the Chief Judge of the state. Onjeh asserted that the governor's action was constitutionally valid and in line with due process. In a statement on Friday, he criticized the National Judicial Council and the Nigerian Bar Association for opposition to the governor's decision, emphasizing that the removal was executed within the constitutional framework provided in Section 292 of the Nigerian Constitution. Chieftain of the ruling All Progressives Congress, Daniel Onjeh, joins us now to talk to us about this crisis. Thank you so much for joining us on Newsday.
Thank you for having me.
Well, you're clearly in support, of this decision, but some analysts are wondering what impact this action by the State House of Assembly will have on the independence and integrity of the Benue State judiciary.
Well, the provision of the Constitution of Nigeria 1999 as amended on the procedure for removal of a chief judge of the state is explicit, unambiguous, and clear, even to the layman. In Section 292 of the Nigerian Constitution 1999 as amended, in subsection 1A Roman figure 2, the procedure was clearly spelled out on who has the constitutional role or responsibility to remove a chief judge. The State House of Assembly, upon receiving an address, can decide to make such recommendation to the executive arm, which is headed by the governor of the state. And accordingly, the governor also is left with no other choice than to implement or to adhere to the recommendation of the House of Assembly. So the decision to embark on that resolution by the Benue State House of Assembly is proper and is well situated in the Constitution of the Federal Republic of Nigeria, because the provisions are clear. The contentions out there is ridiculous. If you study law, particularly to the status of being a judge, you must be proficient in the language in which you undertake the study of the law. If you study law in Swahili, for example, you must be very proficient in Swahili. In this case, it is English. And like I said, the provisions there are unambiguous. If you look at Section 292, subsection 1A, Roman figure 2, it expressly stated that the responsibility lies in the hands of the State House of Assembly, between the State House of Assembly and the governor of the state. Isn't it ridiculous that the State House of Assembly that can impeach the governor is now being said to be incapable of removing a chief judge who is an appointee of the governor? What those opposed to this position are quick to present to the public, thereby misleading the public, is Section 292, subsection 1B. And like I said, English is the language that is used to study law and apply law and interpret law in Nigeria. If you look at subsection 1B, from the very first line, the introductory line, it is a transitional clause that introduced the line, stating that in any case other than the provisions of section 1A, which clearly means that there are other ways that judges, particularly a chief judge of a state, can be removed. Section 292 1A subsection Roman figure 2 talked about how in understanding the context for which these arguments are precipitating, we must first of all appreciate the status of a chief judge of a state. First, he is a judge, he must be a judge. And secondly, being a chief judge of the state is a mere political appointment. The Benue State House of Assembly did not sack Justice Kpambise as a judge. That power they do not have. That power is completely that of the NJC, which is what the framers of the law envisage in section 1AB. That is the only role, or the only time the role of NJC was mentioned in section 292 of the 1999 Constitution as amended, where they can discipline, judge, or recommend the discipline of a judge. This, I believe, the framers of the law have done just so that no arm of the government will abuse the principles of separation of powers or checks and balances in a political system.
Right, right. And
so therefore,
yes, would like to interrupt you just for the sake of time, please.
So therefore, the governor has the power.
All right, thank you, Daniel.
To remove
Daniel,
a chief judge
we
that he
hear
has
you.
appointed.
Very, very understandable. But beyond these legal arguments, what are the underlying social and political dynamics that are contributing to this crisis? Well, as we know, we don't know. Some are assuming that it is politically motivated, the removal of the chief judge. So how will this impact the legal proceedings and things going forward?
I commend you for this question. It will appear that so many political analysts or pundits who have remarked on this issue are parrying the truth or playing the ostrich. We must tell ourselves the truth. There is definitely a political undertone in all of this brouhaha that has engulfed the judiciary in Benue State. And the chief judge of the state is liable for that because of certain misconduct he was alleged to have committed. For example, the chief judge of the state granted waiver for security deposit for petitioners. And I have a copy here, if you permit me. I will quickly read so that you see where the judiciary in Benue State has taken a partisan dimension. And this is it. Permit me to read it for you. Now, this is a letter written to the Secretary of the Benue State Local Government Election Petition Tribunal, ostensibly by the chief judge. The directive was passed by one Franca N. Yua, which is the chief registrar. Now, waiver of payment of deposit for security by petitioners. The above subject matter refers, I hereby convey approval of the Honorable Chief Judge for waiver of payment of deposit for security by prospective petitioners. 2, the directive is in response to appeal and general outcry prospective petitioners for their inability to pay deposit for security. For want of time, I want to stop here. a judge who ought to be in his courtroom is responding to a general outcry of petitioners, which means he had an interface with petitioners. That alone is a compromise. We know that judges are the most revered people in the society. You hardly even see them. They hardly interact or mingle with litigants. But in this case, Justice Pambise shows clearly that he interacted with the petitioners, which means they were plotting their ways for a program end, already an end that had been programmed at the Election Petition Tribunal. The Chief Judge of the state, yes, can constitute a panel to sit on the election petition for the local government election. And once the Chief Judge does that, he becomes functus officio. It means his job ends there. He has no power to amend the law. For your information, the law which provides that petitioners must pay security deposit. I am a politician. I have run for senatorial elections twice in the Benue South, and I've been at the Election Petition Tribunal back to back. I had always paid security deposit, and it is a precursor for filing election petition. In fact, if you do not have that, you are not considered to have filed election petition. So therefore, if the Benue State House of Assembly, in their wisdom, have made a law to state that election petitioners must pay security deposit, it is a law. Therefore, the action of the Chief Judge of the state is overreaching.
Mr. Onjeh.
It is an abuse of the principles of separation of powers and an abuse of his own office, because he has indicated interest in the ongoing election petition tribunal sitting in Makurdi for local government elections.
Very well said. Now allow me to...
And that is the crux of the matter.
Very,
the political
very
undertone
you
that you
support
asked,
this decision.
if I have the time to clear you.
Mr. Onjeh, if you'll just allow me, because we are almost completely out of time, we understand that 13 members of the House have been suspended for opposing the recommendation to remove the Chief Judge. And I'm wondering if there is a law compelling them to agree with the recommendation. Aren't the members of the House allowed to have dissenting voices anymore?
Well, I don't hold brief for the House of Assembly in Benue State, but I do know that the requisite numbers required for the House to take the decision it took on the issue of Justice Pambise was gotten before the decision was taken. That, for me, I think, is what is important. We just heard from the news that they were suspended, and the reasons that were advanced for their, one of the reasons advanced for their suspension was that they took part in the decision only to leave the chamber there and disparage the State House of Assembly. So, but that completely is the prerogative of the Benue State House of Assembly. I do not hold brief for them. My concern here is the application of the law. The judges are not meant to review or amend laws. They are meant to apply laws and interpret them. So what Justice Pambise have done clearly is overreaching. He ought not to have written for waiver for petitioners. And because of several other things, allegations, barrage of allegations that trace him, there's this suspicion in the air. You won't believe that the people or the petitioners at the local government election petition tribunal are members of APC. This brings us to the political undertone you raised that I commended you about. There are two camps in APC in Benue State, and we must call a spade a spade. one of the camps, which is the camp of the erstwhile or sacked chairman of the party in person of Oxen Agada. You also recall I was here on your TV station some time ago on the heels of my petition to the national chairman of the party of APC regarding the anti-party activities of the same Oxen Agada that sabotaged my senatorial election, where he shortchanged my agent, the party agent that ought to protect my vote. He changed the whole of my agent. Aside from my polling unit, I didn't know any agent that stood for me in the over 1,300 polling units of Benue South. He changed it when I had even paid the fees to enlist my agent. And secondly, the funds that were made available by the party for the election, he diverted in cohort with some other persons to use in working for my opponents in the election.
Well,
that
Daniel,
was the basis of the petition.
Daniel,
Finally,
we have
justice
to
has been served.
interrupt you.
The
Thank you so
Bola
much
Tinubu,
for joining the program
next.
this afternoon. It was great. Daniel Onjeh, the chieftain in Benue State for the All Progressives Congress.